Good evening, everyone. Today, we are going to discuss a very practical and essential legal topic, that is, common drafting mistakes in contracts and how to avoid them. Now, contracts are the backbone of every business relationship, whether you're dealing with employment, partnership, freelancing, or commercial transactions. Contracts always define your rights and obligation. Now, however, many disputes arise not because the parties act in bad faith, but because the contract itself was poorly drafted. Now, in India, contracts are governed by the Indian Contract Act 1872, and only those agreements that meet the legal requirement are enforceable. So, today we will identify the most common drafting mistakes and learn how to avoid them effectively. Now, before discussing the mistakes, let us understand first what it takes to create a valid contract. Under the Indian Contract Act, a valid contract needs to have your offer and acceptance, lawful consideration, free consent, competent parties, and lawful object. If any of these elements are missing, the contract becomes void or unenforceable. Another important provision is your Section 10, which defines what exactly is a valid contract. Section 73 and 74, which deals with damages for breach. Section 27, which restricts agreements in restraint of trade. Understanding these provisions, they usually help you avoid serious drafting errors. Now let's move on to the core of today's session, that is the most common drafting mistakes that is made by lawyers. First and the foremost, which I've also mentioned in my previous videos, is using ambiguous language. One of the biggest mistakes that lawyers make is using vague or unclear words. For example, the party shall deliver the goods soon. Now, here, what does the term soon mean? Is it one day? Is it 1 week? Is it 1 month? Is it 1 year? Courts may interpret ambiguity very differently, leading to disputes. The solution for this, always use precise and measurable terms, such as specific dates and timelines. For example, instead of saying soon, you can say within 30 days of the receipt of the advance. Now, that is not any specific date, but it still has a timeline saying that it is XYZ date after a certain incidence happens. Second mistake is failure to define the key terms. Now, contracts often use terms like confidential information, services, deliverables, but they always fail to define them. This often creates confusion during enforcement. The solution for this is always have a detailed definition clause which is very specific to requirement of your clients. Using a standard clause is okay for understanding a reference, but have it very specifically drafted with respect to your transaction. Ignoring jurisdiction and governing law. Now, many contracts forget to specify which law applies, which court has the jurisdiction, and this often leads to unnecessary litigation. The solution for the same, clearly mention that this agreement will be governed by laws of India and subject to jurisdiction of Mumbai courts. Now, why is it mandatory to have it, or why is it always beneficial? Because you can then avoid disputes. For example, if one of your parties is an Indian company, one is a foreign company, in that case, this clause is very important. Then comes an unenforceable clause, which is a clear violation of Section 27. Now, a common mistake that a lot of lawyers do is adding something overly restrictive clause. For example, your non-compete clause after employment, restrictions on profession. So, under Section 27 of the Indian Contract Act, such clauses are generally void. Always draft a reasonable confidentiality clause instead of restricting the employment. Next mistake, incomplete or missing consideration. Now, as we discussed earlier, consideration is a very essential clause. If your contract does not have, or it does not clearly state what each party receives, it may not be enforceable. So, clearly mention what are the payment terms, what are the services or obligation. Poorly drafted payment terms. Now, many contracts fail to specify the payment schedule, the mode of payment, penalties for delay. This often leads to financial disputes. Always include detailed payment clauses with timelines and consequences. No termination clause. Now, some contracts do not explain how an agreement can be terminated, what happens after termination. Your solution: always include termination conditions, notice period, and post termination obligation. Now, absence of dispute resolution. Again, right now, what I'm doing is I'm talking about the role of each boilerplate clauses and how you draft a wrong, you drafting a wrong boilerplate clause can sometimes also be a huge disaster for your clients. Dispute resolution mechanisms looks like, a clause that you would always copy paste. But without a proper enforceable dispute resolution clause, parties directly go to court and it also increases the time and cost. Include your arbitration under Arbitration and Conciliation Act, mediation, or if you have any negotiation step. The biggest disaster of copy pasting drafting. Now, this is one mistake most of the lawyers make, and many people just blindly copy paste the templates from internet without customization. This is what often results in irrelevant clauses and conflicting provision. It is not only lawyers, a lot of people, just to save a few rupees, a few amount uh, on lawyers, they just copy paste the template and chupka do usko. Always tailor your contract to your specific transaction. Now, again, when you have these copy paste clauses, what happens is there is always inconsistent clause. Sometimes different clauses, they also contradict each other. Like one clause may say that the payment is in 30 days, another may say payment is within 45 days. So always review your contract for consistency before finalizing the same. Now, post COVID and with the Iran war, etc., the situation has changed. So lack of force majeure clause can be a huge disaster for you. What happens in case of events like pandemic, natural disaster, or war? It can disrupt contracts in ways you cannot think. Now, without a force majeure clause, liability becomes very unclear. So always include a clause which covers, unforeseen events. Improper stamp duty. Now, in India, a lot of contracts need to be stamped. An unstamped or insufficient stamp contract, it may not be admissible as evidence. So always pay your stamp duty according to your respective state laws. Now, there is no limitation of liability clause. Now, sometimes you just put a random liability clause that everything, the entire liability comes on one part. Now, that is a very unfair agreement. Without a proper liability clause, it becomes unlimited and it's unfair for one of the parties. So always cap the liability clearly in the contract. Ignoring boilerplate clauses like entire agreement, severability, amendment, notice, just copy pasting these clauses are also disaster. You need to check whether, for example, when you're drafting a severability clause, which clauses will be enforceable even if one of the clauses, become void. Customize it. As I said, customization is the solution for drafting a good contract. They're often ignored, but these are very crucial clauses. So include your standard boilerplate clauses irrespectively. Poor drafting of indemnity clause. Now, indemnity clauses sometimes are too broad or sometimes they are very vague. Under Section 124 of the Contract Act, indemnity is something that has to be clearly defined. So always specify the scope, limits, and conditions. Now let's talk about what the judicial interpretation or what the courts say about the contracts. In Central Inland Water Transport case, the Supreme Court had held that unfair and unreasonable contract terms can be struck down. In Fateh Chand versus Balkishan Das, the court had clarified that compensation needs to be reasonable under Section 73 and 74. In ONGC versus Saw Pipes Limited, the court had emphasized that clear contractual terms are very essential for enforcement. Now, before finalizing any contract, you need to ensure that there is clear language and definition, there is legal compliance under the Indian law, there is no restraint of trade violation, proper dispute resolution clauses there, stamp duty compliance is done, and there is internal consistency. Now, to conclude this session, I would like to say that contract drafting is an art and a science. A well drafted contract, it always prevents the disputes. It protects the rights of both the parties, not just one party. It saves time and money. But a poorly drafted contract can only lead to serious litigation consequences. So always remember that clarity in your drafting is the best form of legal protection. Thank you so much, and I'll catch up with you in the next session, which will begin in the next 5 minutes.